Good morning, Miss Francine. This is Brent. Brent Allen Winters, commonlawyer.com, www.commonlawyer.com. We always want to do a question out of the Catechism on the Constitution of the United States. We'll do a little here. And then we're going to go to the Bible. We're going to go to Exodus chapter 21, verse 34. The Catechism, question 256. What judges sit in the circuit courts of the United States? This is the Catechism on the Constitution of the United States, Arthur J. Stansbury. Question, and the questions and answers. What judges sit in the circuit courts of the United States? Circuit courts, that's the court where we have a jury. That's the low-level court called the circuit court. What judges sit there? He says the judges of the United States Supreme Court. What? Judges of the Supreme Court of the United States sit in the circuit courts? What is he saying? Well, I told you yesterday, in my case, I was indicted by a federal grand jury for conspiracy against the United States. I said, I'm not doing any plea bargain. I'm going to make you prove it. It was a tough time for me, as you can imagine. I was facing a lot of years in federal prison. I said, I'm going to trial. I don't care. I'm not going to make some kind of a plea bargain because I knew I had the evidence. And sure enough, after 6 weeks of trial at the lower level court, the jury sprung me, but then we appealed a point on it. It's a long story, not to get into the details, confusing. But a justice from the Supreme Court of the United States sat on my appeal because they wanted to try to nail something that the Supreme Court of the United States would not overturn. That's really what it boiled down to. That's how vicious they are. Okay, it says here, the judges sit in the circuit courts. What judges sit in the district courts of the United States? He says district judges. Now, this was written in 1828. Have things changed? Yes, considerably. In the district courts of the United States, I said circuit. I gave the wrong impression, I do believe. When I say circuit court here, we're talking about the courts of appeals. But the Supreme Court justices do sit there, as I just said in my case, as invitation, by invitation. Justice Taney of the United States Supreme Court delivered one of his most famous opinions while sitting in the district federal court, the trial court, by invitation. That's called the Dred Scott decision. That wasn't the Supreme Court decision. That was a district court decision, if my memory serves me correctly. But things were done different then. Why? Because some of you get this, there's just so much to it. I'll do the best to explain it. The only, again, to say it, and this bears repeating, the only court that the Constitution of the United States establishes is the Supreme Court of the United States. That's the only court. But the Constitution of the United States gives to Congress authority to establish other courts under the Supreme Court of the United States. But those other courts established under the Supreme Court of the United States, our Constitution did not directly establish. No, they left that up. Our Constitution delegates authority to Congress to do that, and they've done it. So we have trial courts called district courts. We have circuit courts called appellate courts. And we have the Supreme Court of the United States. So you can appeal from the trial court to the appellate court in your circuit, and from the circuit court to the Supreme Court of the United States. And that's what he's talking about here. But things were different then, because in the early days, before Congress had established all those lower courts, when the only real court was the Supreme Court of the United States in the federal court system, because that was the only court, that court impaneled juries and tried cases. That really happened. And they can still do it today if they wanted to. The Supreme Court is not dependent on Congress unless they want to do what Congress says. They can do anything they want, just like Congress can do anything it wants within the bounds of the authority the Constitution has given it, and the Supreme Court of the United States the same way, and the President of the United States the same way. Let me repeat it. The circuit courts, and I didn't understand when I first read this here, I'd forgotten the circuit courts, or what he's talking about are the appellate courts of the United States. And I think I might have misquoted that. Miss Francine, there may be a place in there. I wouldn't want to leave in there. That's all I'm saying, because I may have said it wrong, and I don't want that to happen. I have to be careful what I say here, and I know I make mistakes. I want to correct them when I can. District courts, district judges sit in the trial court level. That's the district court level. That's the most local federal court that you have to you, and that's the way it is all over the United States. What kind of cases are tried in the courts of the United States? Answer: any case must be tried there in which the dispute is about the true meaning of any part of the Constitution. Now, as a wordsmith, a man that uses words, he knocked the ball out of the park on this one. He said it well. Let me repeat that. The only cases that the courts of the United States should allow in are cases where there's a dispute about the true meaning and application of some part of the Constitution of the United States. Period. That's the only jurisdiction that the federal courts have to hear cases about the meaning and application of any part of the Constitution of the United States. A very narrow jurisdiction. Remember, state courts have unlimited jurisdiction. They can hear any case about anything that anybody wants to fight about before the courts. As long as it's a real case in controversy, there's a real dispute where the parties stand to lose life, liberty, property, or a combination thereof. Our Constitution says it's a common law standard, real case in controversy. Our courts in America do not entertain hypotheticals. Somebody come to the court with a question, well, what would the court do in this case? They say, get out of here. No, if there's no real fight, we're not going to talk about it. We're not going to accept the case. Why? Because only in a real fight where people have a dog in the fight, where people have skin in the game, or somebody stands to lose life, liberty, property, or a combination thereof, only then will the two sides lock horns aggressively enough that the truth and the true application may bob forth. When you go to court in America, unlike the rest of the city law world, we go to court to fight. We really stand to lose something. So we know the issues are sharpened. Only in battle are the issues sharpened to where the truth has a real opportunity of bobbing forth. This is Brent Allen Winters, commonlawyer.com, www.commonlawyer.com.